So we're going into the regulation. I'm going a bit earlier. I want to see which, the paragraph 23, 25. Oh yeah, that's a good one. It's under chapter section C. Notice of third party notice to a third party. Okay, 22. I'm starting to read. A defendant may give notice to a third party to any person in case where he is this entitled from him he to participate. Uh, intermittent broken phone. Anyway, do our best. Perform an action with respect to the relief claimed from him, or if there is a common factual or legal relationship in the matter between him and the third party which involves the subject matter of the claim. The content of the message and its verdict. 23. The regulation regarding the filing of a statement of claim. So, that's the initial thing where okay. A statement of defense and a statement of reply, as stated in paragraph A of chapter C, shall apply with the necessary changes to a notice to a third party, to a statement of defense of a third party, to notice against him, and to a statement of reply to such a statement of defense. Complicated. A notice to a third party shall be accompanied by copies of the pleadings filed in the suit if they were not previously produced. A notice to a third party shall be served within the time set for the filing of a statement of defense in accordance with Regulation 9. So we have, 60 days. The law of a third party to whom a notice has been served is the same as that of the defendant for all intents and purposes, but he is not entitled to file a counterclaim. If a third party wishes to dispute the notice against him or the statement of claim filed against the party who gave the notice, he shall file a statement of defense within 60 days from the day on which the notice was served on him. The court shall order the timing of the hearing of the notice to a third party and the order in which it is conducted. Okay, we're going into Article D. Pleadings and documents. Miscellaneous provisions. It's exposing the documents. Consolidation of causes of action. 24. A plaintiff shall consolidate in one statement of claim all the causes of action against a defendant due to the same set of facts, and he may consolidate in one statement of claim other causes of action against the same defendant, all subject to a substantive jurisdiction of the court, claiming the full remedy and all of the remedies for one cause of action. 25. A plaintiff shall include in a statement of claim the full remedy to which he claims he is entitled due to the cause of action and shall not be able to file a claim for the part he did not claim. Okay. Family court is a bit different. We could add other stuff, but anyway. A plaintiff shall include in the statement of claim all the remedies requested for the single cause of action, unless the court permits him or the law permits him not to sue in the framework of that claim. Permissions from court shall be granted only in the framework of a request for split remedies. The court will rule on the request for split remedies until the end of the pre-trial. Litigants in the claim. Litigation is apparently a court there. Didn't realize that. But it's while, any negotiation, any thing that is done in front of a court. It is permissible to attach in one statement of claim as plaintiff or as defendant any person necessary for the purpose of deciding the claim efficiently and completely, providing that the claim raises a factual legal question common to all parties. Be a plaintiff who has doubts as to the identity of the person from whom he is entitled to relief may join several defendants so that the question of liability and its scope Respect of each of them will be clarified during the hearing. Interesting, I didn't do that anyway. Reliance on various facts. 27. A party is not entitled to raise a claim in the pleadings that there is a contradictory of or alternative fact unless he has verified in an affidavit that the fact as they are not known to him, raising preliminary arguments in a statement of defense. 28. A preliminary argument that was not specified in the statement of defense will not be raised at a later stage unless the court has given permission to do so. Claim of lack of authority, foreign jurisdiction clause, or improper forum. 29. A party shall raise a claim of lack of authority, a foreign jurisdiction clause, on an improper forum at the first opportunity after the filing of the statement of claim. If a party does not raise these claims on such a date, the court may award costs in favor of the opposing party or in favor of the state treasury. Indicate the deadline for submission. If a party submits a statement of claims to the court, he shall specify in the margins of the title of the document the deadline on which he must submit the statement of claims in accordance with these regulations or in accordance with the court's decision. And if he responds to another document, also the date in which that document was served on him. Form of statement of claims. 31. The director of court shall order technical instructions regarding the form, attachments, and structure of each document. Drafting a statement of claims. 32. A statement of claims shall be drafted in a manner that is not degrading, shameful, or offensive. Failure to receive a document. 33. A legal secretary shall not receive a document that does not comply with the requirements set forth in this regulation or a court order. I mean, you have a real technical stuff with the fonts and a paragraph have a line and a half between paragraphs. They really made it really set. Actually, if you do it online, you get a ricochet. I mean, you got a feedback, I think, in half a day, where the computer managed to scan just the technical font and grammar and all of that. I mean, you can, lose a life on fonts and a line and a half, and if it's David or unbelievable. A request for a stay of execution of a decision, a request for collection of preliminary testimony and the answers of such request, a proceeding under the Prevention of Domestic Violence Law 1991, and a request for an order prevent threatening harassment under the Prevention Threatening Harassment Law. That's a different one, isn't it? If the date for submission of a document has not yet passed, the defect may be corrected within the period of time remaining for submission. If a statement of defense, reply, counterclaim, third-party notice, request for leave of appeal, and appeal is not accepted by a legal secretary, the defect may be corrected within 7 days from the date on which it was not received, or until the last day of its submission, whichever is later. Notwithstanding the provision of sub-regulation A and B, if a party is not represented, the legal secretary shall also specify the action that the party is required to take in order to remedy the defect. Okay, I'm stopping here.